into the final round of the 1993 Philip C. Jessup International Law Moot Court Competition. This morning you will be viewing the teams from the University of Melbourne, Australia, and the University of Hawaii. The University of Hawaii will be representing the applicant of Bastonia. Australia will be representing the respondent of Frontera. I would first like to thank everyone who had a part of the competition up front. Many of them are still upstairs running around trying to set things up for this morning and to ensure that everything goes properly today. But especially those of you who are participants who stayed for the final round, we appreciate your being here. I would also like to take a moment to allow one of our teams who came from quite some far away to make an announcement that we were not able to make earlier during the course of the week. If I may have the gentleman from the team from Papua New Guinea to come up for treatment.
Ladies and gentlemen, on behalf of the team from Papua New Guinea, we would like to thank the organizers of Jessup International Law Moot Competition. We also would like to thank the friends of Jessup Moot Competition, the judges, the participants. To show our appreciation, we would like to present a small gift to the organizers of the Jessup Moot Competition. Here's a present. It is the crest of it is the national emblem of Papua New Guinea. On it you can see the bird of paradise with a kundun drum and arrows. We would like to leave it with the organizer.
The procedure for this morning will be that we will introduce the oralists to you. We would also this year like to draw attention to team members who will not be arguing on behalf of each team. Only 2 of the oralists will obviously argue for each team this morning, but 5 have participated. I think 4 for one, 5 for the team. And we'd like to make sure you know who they are as well. So at this point, I would like to begin introducing the oralists. For the team from the University of Hawaii, the team captain and the gentleman who was voted best oralist in the preliminary rounds of the competition, Mr. David McCauley. Mr. McCauley will also be serving as counsel to the team this morning. The second member of the team from Hawaii would be Carlo Winter. The gentleman representing the team as agents for the arguments this morning will first be Mr. David Foreman. And Mr. Andrew Blum. And for the team from the University of Melbourne, Australia. I hope I have these in the right order. The first member of the team who will not actually be arguing this morning is Mr. Tony Pittman. Mr. Richard Boodle. Serving as the counsel position to today's team will be Mr. Byron Coe. And arguing on behalf of the team from Melbourne will be Ms. Susan Brennan. And Ms. Allison Duxbury. We have moved this year for the first time to a 5-judge panel for the final round of the competition. The judges are upstairs now, but I would like to fully introduce them to you as they will only be mentioned by name as they come in. I'm not sure who they've elected as president from amongst themselves of the court this morning, but the judges will be in no particular order of importance. Mr. Miguel Diaz, the legal advisor to the Foreign Ministry of the Nation of Mexico. Ms. Mary Footer from the British Institute of International and Comparative Law. Mr. Talbert Fox, Chief International Counsel of Exxon Corporation. Dr. Farin Mirvahabi from Falls Church, Virginia, who is a former State Department official. And Mr. James Grossman, Chairman of the United States Foreign Claims Settlement Commission. We expect to have a very lively round this morning. To be participants, so I'm laughing at the difficulty of the judges today. I wish both of the teams the best of luck. We will call up and have the judges prepare themselves. They should be down shortly. We thank all of you for attending this morning. Following the competition, we will, of course, send the judges back upstairs for 15 minutes to deliberate and then make a presentation of awards. And we would appreciate it if each of you could bear with us during those deliberations. And generally be aware that the judges will come in probably unannounced. And if you could rush back into the room afterwards very quietly, we would appreciate it. Thank you much.
The International Court of Justice is now in session. President Mary Footer and the Honorable Judges Talbert Fox, Farin Mirvahabi, Luis Miguel Diaz, and James Grossman presiding. The case before the court is the matter of Bastonia versus Frontera, and the applicant and respondent teams are each allocated 45 minutes to present their respective pleadings.
You may be seated. Would the applicant care to proceed?
Madam President, Your Excellencies, my name is David Foreman. At this point, I would like to use 5 minutes for rebuttal. Your Excellencies, I'm joined today by my co-agent, Mr. Andrew Bunn, and of counsel, Mr. David McCauley. We represent the state of Bastonia, the applicant in this case. Your Excellencies, Bastonia respectfully requests this court, during its deliberations, to keep the following principle in mind. When you take something that does not belong to you, you must either give it back or pay for it. With respect to the issues raised in the instant case, Bastonia asks this court to adjudge and declare, first, that Frontera has violated its international obligations, either by A, failing to restore private ownership to the Fronteran pharmaceutical company, Pharmco, or B, by refusing to compensate Bastonia's international pharmaceutical company, IPC, for its consequential losses, both as a leaseholder and as a shareholder. Second, Bastonia asked this court to determine that the current government of Frontera is responsible for these violations. In my submissions, I shall address the latter issue, that of responsibility, in 2 parts. First, with respect to Bastonia's standing. In other words, our right to bring this claim before the International Court of Justice, as set forth in Section 5 of our memorial. Second, I shall discuss the issue of state succession, arguing that a continuity of obligation exists between Frontera's colonial government and its revolutionary people's government. During his submissions, my co-agent, Mr. Bunn, will address the illegality of Frontera's actions under international law. First, again in two parts. First, under the bilateral investment treaty between Bastonia and Frontera. And second, under customary and generally accepted principles of international law, including the requirements of appropriate compensation and non-discrimination. If the court has no preliminary observations, I shall provide a very brief statement of some of the facts that will address the court, which give rise to Bastonia's claim before the court today. Your Excellencies, in 1990, during an internal conflict, Frontera's colonial government nationalized all the manufacturing concerns in its territory, including Farmco. In 1991, after the revolution had ended and the Revolutionary People's Government of Frontera had assumed control, Farmco was excluded from Frontera's reprivatization program. Subsequently, Bastonia's citizen, IPC, sought compensation for this action in both Frontera's administrative and judicial tribunals. Although the compromis is silent with respect to the specific claims brought by IPC, other than, among other things, the guarantee provisions of the bilateral treaty. The compromis states that IPC exhausted its remedies in Frontera. Thereafter, IPC brought this claim to Bastonia, and Bastonia sought to negotiate in good faith with Frontera. Unfortunately, Frontera assumed an obstinate negotiating stance, asserting that it had the right to nationalize, it always had the right to nationalize a domestic company without providing any compensation. As a result, the parties reached an impasse and have agreed to bring this claim before this court. If the court has no further observations with respect to the facts in this case, I will proceed with the first part of my submissions, that the issue of state responsibility. Your Excellencies, I will deal in two parts, standing and state succession. With respect to Bastonia's standing in this case, Bastonia has two independent grounds for standing. First, based on the property lease, which was entered into between the Fronteran colonial government and the the International Pharmaceutical Company, IPC. Although the terms of this lease are not, although compromis is silent with respect to the terms of this lease, it is Bastonia's submission that this lease is akin to an internationalized contract, as discussed by Professor Dupuy in the Texas Overseas Petroleum case, wherein he enumerated three principles that would apply for an internationalized contract to be held. First, because an internationalized contract, such as the property lease and subsequent investments, links the economic and social progress of the host state with the success of the company that is associated with that property lease. And second, that the long duration of a contract, 12 years in the Topco case, 100 years in this case, that this long duration implies a close cooperation between the nations. And thirdly, that the purpose for entering into an internationalized contract of this nature is to secure the provision of an equilibrium between the parties. Beyond the independent basis of standing in the property lease, Bastonia also has a basis of standing in the denial of justice, that Frontera's administrative courts and tribunals did not reach the merits of IPC's claim. And this principle was discussed in this court's predecessors, the decision of this court's predecessor in the Mavromatis Palestine concessions case. Now, the issue of standing is raised primarily because this court in 1970 denied the claim of Belgium versus Spain, attempting to assert the claim of a Canadian corporation. Therein, the court expressed a concern for for confusing the sphere of international economic relations by allowing a broad spectrum of claims, firmly recognizing in the Barcelona traction case that the primary basis of standing for a corporation is its state of incorporation. However, as distinct from the facts in the Barcelona traction case, Bastonia is asserting the claims of its own corporation, and furthermore, the particular facts of this case specifically apply to a theory discussed by the majority at page 48 of its opinion, and furthermore clarified in a foresightful opinion by Judge Jessup of this court, in which he stated that there is a right of diplomatic protection where the state whose responsibility is invoked is the national state of the company which has been wronged. The reason for this theory is that where the primary basis of bringing a claim, the state of incorporation, where that state refuses to bring that claim for whatever reason, in the case of Canada, it may have been Canada's decision not to pursue this claim in its court.
Excuse me, Counselor. I think the issue is whether Bastonia can protect the rights of its shareholder company, IPC, and is entitled to protect under international law against what you argue in your brief to be a right of non-discriminatory national treatment. It seems that the facts indicate that at the time the investment was made, it was very clear to IPC that it had to operate through a locally incorporated company, which it did not have control. And the issue I'd like to hear you address is whether by doing so, it did not submit, in effect, to local jurisdiction, knowing that it was subject to a sovereign discretion of Frontera in domestic treatment and had really given up international law protection.
Yes, Your Excellency. Bastonia did submit itself to Frontera's jurisdiction. However, once a nation has accepted foreign investment, it is bound to treat that investment fairly. And this is the principal basis of Bastonia's claim. With respect to standing, representing its shareholders, Bastonia relies first on the bilateral investment treaty between Frontera and Bastonia. I note to the court that in Barcelona Traction, there was no treaty for the court to apply. Bastonia freely admits that the application of this treaty is in dispute, and I will address this issue in the second part of my submissions with respect to state succession.
Counsel, I have a question. You said that you had exhausted your remedies in Frontera. Are you telling this panel that you actually you had a forum clause in the investment treaty, investment agreement that you had? Did you go to the local court? Is that what you're trying to imply?
Excuse me, Your Excellency. The compromise is silent with respect to the presence of a forum clause. However, there are ellipses provided in the compromise, so it is possible for this court to infer that there may or may not have been such a clause. However, the facts do state that Frontera did seek a claim for compensation in both Frontera's administrative and judicial tribunals. This is at page 3 of the compromise. And although the compromise states that Frontera sought compensation under the guarantee provisions of the Bilateral Investment Treaty, Article 10, which states Frontera must provide the most constant protection and security to the investments of citizens or companies of the other state, I note to the court that the language in the compromise is inter alia, and the court may infer from this fact that IPC sought claims based on, brought claims based on other causes of action. The courts of Frontera did not reach the merits of its claim, and the subsequent sentence in the compromise states that IPC exhausted its remedies in Frontera. I would note finally on the issue of standing that there are specific equities to be considered in this case that were discussed in Barcelona Traction, which the court could rely on here. Specifically, Barcelona Traction noted that where there is a structural reordering of a host state's economy, there should be granting of standing. If the court has no further observations with respect to the issue of standing, I will turn to the second part of my submissions, that of state succession. Your Excellencies, there is a continuity of obligation between the Fronteran colonial government and the Revolutionary People's Government of Frontera, because a mere change of government does not excuse a successor government from the obligations entered into by its predecessor government. First of all, Your Excellency, I would point to the actions of Frontera itself, which the court may infer from the compromise viewed itself as merely a change of government, although subsequently it asserted that has asserted that it is a newly independent state. Only 3 months after the Revolutionary People's Government assumed power, Frontera's ambassador stated to Bastonia that it was her country's hope to continue a long-standing tradition of political and economic cooperation between the two nations. Given that this new government was only in power for 3 months, it is permissible for this court to conclude that Frontera considered itself to be still Frontera, not a newly sovereign or newly independent state.
Counsel, I have a question. Are you telling us that this continuity doctrine that you are basing your argument on can go on even if the newly independent state is totally different from a colonial regime in every respect?
Your Excellency, that would not be Bastonia's submission. But based on the facts of the instant case, where Frontera had substantial autonomy prior to attaining full independence, that the theory of continuity applies. I would note to the court the example of India, which had substantial autonomy since 1919 and only achieved formal independence in 1947. There, like Frontera, there was no change in the population in Frontera, no change in the boundaries, no change with respect to the conduct of international relations. The only change was in the internal governance structure of Frontera. Now, with respect to the internal governance structure, I would point to the examples of Australia and Canada, who, for a time, had their governor-generals appointed by another nation. Now, it is true that in Australia, Articles 57 and 61 of its constitution provided that the governor-general would be appointed by another nation. However, it is permissible for the court to infer that Frontera's constitution also provided such an issue. The compromise, however, is unfortunately silent with respect to this matter. Your Excellencies, I would also note Frontera's position as an original member of the United Nations. Like India and the Philippines, Belarus, and the Ukraine, Frontera was an original member of the United Nations despite the lack of full independence. Although the cases of Belarus and Ukraine were clearly a political compromise and that they did not truly represent themselves, Frontera is more closely akin to the case of India, where India was represented in its had its own international relations capacity. Yes, Your Excellency.
Legally speaking, you are referring to a case of succession of states or recognition of states or change of government, because you are basically referring to cases that had something to do with your case, but your own case, legally speaking, which is how you could approach.
Yes,
out
Your
of these three or some other that you could think.
I believe I understand your concerns, and I would point to the fact that the compromise states that Frontera, throughout basically this entire century, since the 1900s, has had substantial autonomy. Although the compromise...
Excuse me,
Yes.
that is not the issue. The issue is you are going to the history. Legally speaking, the issue is what?
Yes.
Taxation of state? Why?
Yes, sir.
Recognition? Why?
Your Excellency, I think I do understand your question now. And the principle that I'm espousing is that the continuity based on a mere change of government as opposed to a succession of states. If there truly were a succession of states, then this theory would not apply. However, even if this court would determine that there is a succession of states, Frontera can derive no comfort, for example, from the Vienna Convention on the Succession of States with respect to treaties. First of all, because it is not customary international law expressly binding upon the party, or...
Excuse me,
yes.
Why is not?
Your Excellency, this convention requires 15 ratifications. It has only achieved 8. And in the Guinea-Bissau maritime boundary delimitation case, 3 justices of this court, Judges Locks, Mbaye, and Bajawi, stated that the convention is only reflective of customary international law with respect to boundary issues. Implicitly, therefore, stating that it does not apply to other issues. However, if this court were to determine that it is reflective of customary international law, Frontera still can derive no comfort from these principles because Frontera, does not meet the definition of a newly independent state under Article 2.1b and f of that convention because it had responsibility for the conduct of international relations. Your Excellencies, if there are no further questions with respect to this matter, I would then turn to the principle that private law obligations, as opposed to public law obligations, will pass even if there is a state succession. The private law principles are based on the social relationships between the parties, as opposed to public law relationships, which are based on political authority. Now, where there is a private law obligation, such as the Economic Development Agreement here, that this type of obligation will pass. If the court has no further observations in this matter, as I see my time is running short, I will turn to the third basis for holding Frontera liable in this action. And that is that Frontera had less drastic means available to pursue the actions which it attempts to espouse here. If it is indeed espousing a right of self-determination, it need not have taken the unilateral action of expropriating Farmco without compensation. It could have passed laws in its own nation which would have met its concerns. For example, providing bonds to the IPC, which IPC could...
Excuse me, you said expropriation, but the case used the word nationalization.
Yes, Your
Why
Excellency.
you use one, and what is the difference between one and the other?
Yes, Your Excellency. Bastonia freely admits that the compromise indicates that this was a nationalization which Frontera purported to take. I indicated that it was an expropriation based on Bastonia's submission that this action was illegal. I see that my time has expired. If the court... Yeah. With respect to the expropriation then, or nationalization if the court chooses to feel, nationalization if it's lawful, expropriation if it's unlawful. In either case, there is a concomitant obligation to provide compensation, and my co-agent, Mr. Bunn, will address this issue. Finally, since Frontera could have provided bonds, maintained IPC's right to vote its shares, or pursued measures to assure that profits from Farmco would remain in Frontera, or since Frontera could have renegotiated the terms of its lease if it truly felt that this arrangement was reflecting an unjust enrichment, that it had less drastic means available to meet its economic concerns. My co-agent, Mr. Bunn, will now address the illegality.
Counsel, let me just ask you, do you think a state has a right to reconstruct a private contract?
Yes, Your Excellency. It would be Bastonia's submission that Frontera does have that right. However, rather than attempting to negotiate in good faith with Bastonia, pursuant to obligations under, for example, a customary international law reflected in UN General Assembly Resolution 1803, it must do so in accordance with international law, in accordance with its international obligations. And Mr. Bunn will address both the bilateral investment treaty and customary and general principles of international law in this respect. If the court has no further observations, I will yield to my colleague. Thank you.
Madam President, Your Excellencies, may it please the Court, my name is Andrew Bunn, and I am the co-agent from the state of Bastonia. Your Excellencies, the issue here today is that of an international taking, a taking without compensation by a country that does not want to ever provide compensation for that which they have taken. Such a taking is nothing more than a confiscation and is sanctionable under international law. Your Excellencies, Frontera incurs an obligation to provide compensation for the expropriation of Farmco under both the terms of the bilateral investment treaty and under general principles of international law. Your Excellencies, I will submit to you today first that the bilateral investment treaty is, in fact, a valid treaty as represented by the Vienna Convention on the Law of Treaties, and that Frontera is bound by that treaty. I will then proceed to principles of general international law that would also bind Frontera to provide compensation for the nationalization.
Counselor, just for a frame of reference, are you going to argue that the treaty states standards which are different than customary international law?
Your Excellency, it is Bastonia's submission that the treaty exemplifies standards of international law in that it provides for the most constant protection of investments, that it has a clause for non-discrimination, and that it has a clause requiring compensation in the event of loss or damage to the property.
And are you arguing that, do we need to find that that treaty is a continuing binding state obligation in order to find on behalf of Estonia?
No, Your Excellency. This court need not find that the treaty is in fact continues to be binding in order to find for Bastonia as principles of general international law require that an expropriation be made for under public purpose, in a non-discriminatory manner, and with compensation. And compensation has, in this case, not been provided, and Frontera does not state that it will ever provide compensation, although it does concede in its brief that general principles of international law do, in fact, require compensation for a nationalization or expropriation.
Counsel, is this treaty relevant at all? Because the investment that was made by IPC in Farmco took place long or prior to the actual treaty. So what's the relevance of it?
Your Excellency, according to the Vienna Convention on the Law of Treaties, to which Frontera and Bastonia both stipulate the validity of that treaty, treaties are to be read in light of their object and purpose. As Frontera, according to the Compromis, was the only known foreign investment in Frontera at the time the treaty was executed, it may be assumed that the treaty was invoked to protect existing foreign investments in Frontera and provide for future protections for foreign investors in both countries. Thus,
Effect.
it does indeed, Your Excellency, according to Article 31 of the Vienna Convention on the Law of Treaties.
Do you have any authority for that in practice?
Your Excellencies, we would look to the practice of oil companies investing in the Middle East, in that they were in fact provide the protections of concession agreements executed between countries and themselves for the extraction of natural resources and minerals.
Are you referring to stabilization and freezing clauses? Did you have any such a clause in your agreement with Frontera?
I'm sorry, I didn't quite hear the clause.
Stabilization or freezing clauses that are typical in oil contracts. Did you have any clause like that in your agreement?
Your Excellency, there is...
Which would protect you from any kind of future taking over?
Yes, Your Excellency. The treaty under Article 10 provides for the most constant protection of investments, and it furthermore, under Article 12, provides for the requirement of compensation in the event of loss or damage to those investments. Apart from that, Your Excellencies, the record is in fact silent on more specific clauses. However, it is Bastonia's assertion that those two clauses represent the minimum international standard as represented in the Electrona Sicula case and the investment treaty, the bilateral investment treaty between the United States and Italy, which would give a right of protection to foreign investments in that country. Your Excellency, returning to my submissions that Frontera is in fact bound by the Vienna Convention of the Law of Treaties and thus, in fact, is also bound by the bilateral investment treaty. I cite the court to Article 26 of the Vienna Convention, which requires that a country in entering into international treaty obligations is bound by those obligations in good faith. Frontera has not acted in good faith here in that it has sought to revoke its treaty obligations without compensation in a discriminatory manner, and has also failed to use the mechanism which would allow a state to escape and terminate treaty obligations provided for in the Vienna Convention. Article 65 of the Vienna Convention requires that a country may in fact terminate its treaty obligations, but it must provide specific notice for the termination of those treaty obligations. In this case, Your Excellency, Frontera has merely unilaterally terminated, made unilateral statements claiming not to be bound by the treaty obligations, and has at no time specifically contacted the Bastonia with regard to termination of the treaty obligations. Furthermore, Frontera could have also invoked Article 56 of the Vienna Convention to terminate the bilateral treaty obligations, but it would be required under that article to give 12 months notice to effect the termination of treaty obligations. And as we know from the compromis, they provided no such notice. Your Excellencies, furthermore, in the alternative, if you should find that Frontera did, through perhaps the diplomatic notes, claim that they were not bound by the treaty obligations, they would nevertheless be bound by Article 45 of the Vienna Convention, which stipulates that a country that conducts itself in a manner acquiescing to the treaty's validity will in fact be bound by the treaty. And it is Bastonia's submission that Frontera did in fact conduct themselves in a manner acquiescing to the treaty's validity.
The Counsel, Frontera may have pleaded and that there is a profound change of circumstances here, res extendibus. What is the applicable law then?
Your Excellency, it is Bastonia's submission that there has in fact not been a profound change of circumstances here, that doctrine under Article 62 of the Vienna Convention is not relevant here because we have merely a change in government, which does not qualify under the doctrine of rebus sic stantibus. And furthermore, an exception to the doctrine of rebus sic stantibus is again Article 45 of the Vienna Convention, which if the country, Frontera conducted itself in a manner acquiescing to the treaty's validity, it would in fact be bound by the treaty. The Fronteran foreign minister, when she presented her credentials to the Bastonian government, stated that she hoped the long-standing tradition of economic and political relations would continue. This Bastonia views as a statement acquiescing, in fact, to the validity of the treaty. And furthermore, the Fronteran government did, in fact, accept those credentials in the hopes that the treaty protections that were have been established over the tradition of economic relations would in fact continue. Secondly, Your Excellencies, the Frontera government passed General Law number 1991-007, in which the Frontera Parliament sought to make null and void acts of the previous regime that did not comport with their current goals. However, that law explicitly exempts treaty obligations from those laws. Again, we have the conduct here, this time by the Parliament of Frontera acquiescing to the treaty's validity. Thirdly, Your Excellencies, as we know from the compromis, Frontera, Bastonia exhausted its judicial remedies in the court system of Frontera. And throughout the course of the exhaustion of those remedies, the Fronteran court system never stated that the treaty was in fact invalid. They merely stated, in fact, this was the highest court of Frontera that stated that there was no private cause of action under the treaty. And in fact, we are here today with the public cause of action. Again, another example of conduct acquiescing to the treaty's validity. Yes, Your
Do
Excellency.
you think this rule of exhaustion of local remedies is a rule of international law always?
Your Excellency,
In what way will affect your case?
Your Excellencies, in general, international law does require that a state exhaust domestic remedy before approaching an international tribunal to solve the problems. However, it is not required that in the exhaustion of those remedies that a court reach the substance of the merits of the case, only that through all channels and means that they have reached the highest court in the land and the domestic tribunals have in fact not reached the merits and have in fact thereby exhausted the remedies available to citizens in Frontera, in Bastonia. And in this case, we do know that in fact that was the case. Your Excellencies, Article 69, Section 2 of the Vienna Convention also stipulates that where a country relies on the validity of a treaty, that reliance will hold the other country to those treaty requirements. In this case, we have, in fact, Bastonia relying on the statements of the ambassador that protections would be given to its citizens. Had Bastonia known that Frontera intended to revoke those protections by the revocation of the treaty, Bastonia would not have had to accept those credentials, would not have had to provide recognition to Frontera, and in effect would have had an extremely effective tool in which to protect their citizens internationally.
I'm a little confused. You are referring to the Stoppel doctrine, but at the same time, you're talking about this agent of the government orally committing its government. But what is the degree of the reliance by Bastonia after the revolution and after they have repudiated their obligations? You have to have certain amount of reliance and detriment in order to adhere to the Stoppel doctrine. What has been Bastonia's reliance and detriment based on just one oral commitment?
That's correct, Your Excellency. You do, in fact, have to have a detriment for such reliance. And in fact, it is Bastonia's submission that the detriment it incurred was its inability to protect its citizens under the treaty. Had it not accepted the credentials and had it not recognized the new Fronteran government, it would, in fact, have been able to, as we know from the writings of Professors Jennings and Watts in the new edition of the Oppenheim International Law text, it would have been able to use that to protect its citizens by either not bestowing the recognition and perhaps allowing the old regime to have a counter-revolution and protect it, and in which case the citizens and the treaty would in fact be valid in that case, or in fact, as we know from the example of the United States, immediate recognition of Israel, that such immediate recognition is an incredible tool of diplomacy, and in fact allowed Israel to become independent much quicker if it had not if it had withheld that recognition. Your Excellency, I would also submit to the court the fact that there was a 100-year lease in which the IPC investors could have looked for a reasonable return on their investments. Unlike like the Kennecott copper case in Chile, the investors could in fact rely on the fact that their expropriations, that their investments would not be expropriated for a reasonable period of time.
Counsel,
Do you consider,
are you
I'm sorry.
Excuse me.
Go ahead.
Counsel, are you telling us that when a company goes to a country and invests for 100 years, there is no anticipation that there might be some risk? So for 100 years, everything would be guaranteed? Is that what you are referring to?
That is not the submission of Bastonia, Your Excellency. It is a submission of Bastonia that for at least a reasonable period of time, there would be some protections provided that, furthermore, that a international contract, a lease agreement of this kind could in fact be renegotiated by the countries if they so desired, as in the bilateral investment treaty. We do object here to the unilateral expropriation and unilateral repudiation of the international obligations. Returning
Counsel, I believe you referred to reasonable return on investment. Did you
Yes,
say
sir.
those words? What does that mean to you?
Your Excellency, we would anticipate that that the investors would, in fact, get some return on their investment at all. However, for the matter before this court today, this court need not adjudicate what is a reasonable return. It need only decide that Frontera is liable for not providing the protections for ownership of property in Frontera.
In fact, what do you understand the return was in this case?
In this case, the compromise is silent on the net return to the investors. It merely states that there was a $50 million gross return each year. This would not, of course, take into consideration the fact that IPC would be paying lease rents, that IPC was, in fact, paying taxes. It does not take into consideration transfer technologies, which would be related to an investment of this kind, a high-tech pharmaceutical venture, the lending of expertise and services rendered. Your Excellency, as I'm running short on...
Let me just follow up one more time.
Yes, Your
on this
Excellency.
same area of concern. Am I correct in understanding that the 49% of the company was owned by Bastonians?
Yes, Your Excellency.
But the return was far in excess of 49% of the profits of the company?
It was not far in excess, Your Excellency. It was the return for the IPC venture was 60%, and the return for the Fronteran investors was 40%. And as this would not be unusual for a pharmaceutical venture capital situation of this kind, in that the IPC venture invested initially $25 million, whereas the compromise is silent as to what the Fronteran investors did invest.
I would agree with you in terms of the business side, but what about the violation of the spirit of the 49% rule?
Your Excellency, I'm really unable to answer that, as the compromise does not shed much light onto the arrangements of stock options, preferred stock, whatever the business arrangements may have been. Your Excellencies, turning to general principles of international law, international tribunals have consistently held that compensation is required in a non-discriminatory manner for a public purpose. In this case, Your Excellencies, no compensation was provided. No country has been able to expropriate without having to provide compensation or without having been censured internationally.
Would you be prepared to distinguish between the right to expropriate and the duty to pay compensation? Are you questioning the right of Frontera to expropriate?
No, Your
Or
Excellency.
are you complaining by the lack of payment, or what?
It is the latter, Your Excellency. The Frontera, Bastonia looks to the General Assembly Resolution 1803 as the current statement of law of expropriation, and does in fact recognize that a country has a right to nationalize and to expropriate, but it must provide compensation for the expropriations. And our objections in this case is that no compensation was provided. Resolution 1803, according to the opinion of Justice Dupuy in the Texaco Overseas Petroleum case, does in fact represent the current standard of international law with regard to nationalization. Your Excellency is also looking to the practice of states. There are over 200 bilateral investment treaties which guarantee prompt, adequate, and effective compensation for an expropriation. These treaties encompass over 97 countries. Your Excellency, as I see my time is run short, I would briefly summarize with the Court's position and yield to Frontera.
I'd like to briefly summarize.
Yes. Your Excellencies, because Frontera has in fact not provided compensation and has made only assertions that what has been yielded in terms of profits in an ongoing business venture would be adequate compensation, this is nothing more than illusory compensation. Bastonia would ask this Court to effectively judge and declare that Frontera is liable for compensation and has acted illegally in not providing such compensation. And furthermore, that the new government of Frontera does in fact accede to its treaty obligations and its international responsibilities. If there are no further questions from this honorable bench, I will yield to Frontera. Thank you, Your Excellencies.
Madam President and members of the Court, my name is Susan Brennan and I appear with my co-agent Alison Duxbury on behalf of the independent state of Frontera. Frontera makes 4 submissions. First, that the nationalisation of Farmco was a matter of domestic jurisdiction. Secondly, and in the alternative, that if international principles govern the nationalisation, Frontera has complied with any relevant principles of international law. Thirdly, that Frontera is not bound by the bilateral investment treaty because of the principles of state succession. Fourthly, and again in the alternative, that Frontera has not breached the treaty. I shall make Frontera's first 2 submissions and speak for 20 minutes. My co-agent shall make the second 2 submissions and speak for 22. We reserve 3 minutes for Sarah Buttle. Your Excellencies, the right of a state to nationalise property within its territorial boundaries in the pursuit of economic self-determination is a recognised expression of the full permanent sovereignty of a state over its natural resources and economic activities. The nationalisation of Farmco was a matter of domestic jurisdiction alone. That is, Frontieran law alone governs the legality of the nationalisation. 2 conclusions of concern to this Court follow from that submission. First, the matter is wholly inadmissible before the Court. Secondly, the issue of compensation, which is most at stake in this dispute, is a matter for determination by Frontera alone. Turning to my first submission on standing. Frontera has assumed management and control of Farmco, its own national. The link of nationality is established by the close and permanent connection between Frontera and Farmco. Farmco pays its taxes in Frontera. Its board meetings are held in Frontera. It was incorporated in Frontera. All its operations are conducted within Fronteran territory. As it is Farmco which has been nationalised, and as Farmco is a Frontieran national, there is no issue of interference with a foreign national's property.
Counsel, this Court decided, did it not, in the judgment in the Barcelona traction case, that the close connection, or sometimes what is called the genuine link, does not necessarily always apply in the case of corporations. The principles applied to nationality of individuals may not apply in the case of corporations. So should we have reference to that particular argument you've just been making?
Your Excellency, Barcelona Traction did refer to a prima facie test of incorporation. It then went on to list the factors which established the close and permanent connection between the Barcelona Traction Company and Canada. If, however, this court prefers simply a test of incorporation, Farmco meets that requirement and was incorporated within Frontera.
The recent cases of the Iran-U.S. Claims Tribunal, in which that the rights of the shareholders of the foreign companies were recognized, and they awarded some compensation, adequate compensation for the rights of the shareholders.
Your Excellency, Frontera seeks to distinguish the decisions of the Iran-U.S. Claims Tribunal because, for the most part, they were all decided under the Treaty of Amity between Iran and the United States.
Not necessarily.
No, Your Excellency, some were decided with respect to customary international law, and I refer to the AIG case in particular. However, with respect to shareholders' rights, in the SEDCO case, it was found that what was required was control, and it was not de facto control which entitled shareholders to bring an action, but in fact actual ownership of shares. Here we have a 51% ownership by Frontera nationals, and according to the test in SEDCO, that will establish that IPC is unable to bring an action. Moreover, in the Barcelona Traction case, the court adopted the doctrine of a separate legal entity, by virtue of which shareholders which sustain damage may look to the company alone for protection. Therefore, IPC, as a shareholder in Farmco, can look only to Farmco to complain of the nationalisation. Bastonia relied upon the equitable exception which was mentioned by the court in the Barcelona Traction case, that where the nationalised company has the nationality of the nationalising state, shareholders will have a direct right of action. However, this was not a proposition, the validity of which was affirmed by the court in Barcelona Traction, nor was it the proposition upon which the case turned. Moreover, Judges Padillo Nervo and Morelli, in their separate opinions, deemed this exception a wholly illogical and arbitrary deduction, and one which detracted from this very doctrine of a separate legal entity.
Councillor, isn't it arguable that the very purpose of Article 10 of the treaty was to indeed, despite Barcelona Traction, to protect the investments of, quote, citizens or companies of the other state, unquote?
Your Excellency, in the Electronica Secular case, the court dealt with this very issue, where a treaty provided standing or provided protection to companies. However, in that case, the US corporations were provided with standing on the basis of specific provisions which entitled shareholders to rights of control and management. Judge Oda, in his separate opinion, declared that in the absence of such provisions displacing the doctrine of a separate legal entity, corporations, or shareholders rather, would not be entitled to bring an action under such treaty provisions.
Counsel, are you saying then that there's no standing for Bastonia? Is that the principal argument that you're making?
Yes, Your Excellency.
Is it based then on the fact that IPC did not own more than 50% of the company?
Your Excellency, in fact, Barcelona Traction dealt with the case where Belgium was stating that it had 88% shareholding, and in fact the court denied standing to Belgium in that case. It is submitted by Frontera that, according to the principles outlined in Barcelona Traction, it is irrelevant what percentage shareholding is held, but that if we look to the decision in SEDCO, it may be that the actual ownership of shares is important.
And the Iran-U.S. Tribunal so held?
Your Excellency, there was a specific provision in the Treaty of Amity which required that shareholders control 50% of the shares before they were entitled to bring an action.
Thank you.
Your Excellencies, Bastonia also relied upon the lease to provide it with standing. However, there at first is no evidence of a breach of the lease agreement, but if in fact there were, it is still not the case that the lease provides standing in an international tribunal. According to principles of private international law, the law of a contract or the law of a lease will be the law of the land, that is, frontier law. Thus, any breach of the lease agreement will be governed by frontier law and is not properly heard before this court. The lease does not amount to an economic development agreement, as was discussed by the arbitrator in the Texaco award. There he was dealing with a concession agreement which entitled a company to exploit natural resources, and we have no such agreement on these facts. Finally, Your Excellencies, there has been no denial of justice, as was suggested by Bastonia. Denial of justice encompasses the notion of procedural fairness. There is no evidence at all on the facts that IPC was denied procedural fairness in the Frontieran courts. Your Excellencies, even if this matter is admissible before the court, Frontera continues to rely upon the right of states to nationalise property within their territorial boundaries, free from international scrutiny. This exclusive jurisdiction of a state over nationalisation is established by General Assembly Resolutions 3171, 3201 and 3281, which reflect customary international law under the decision of Nicaragua. Resolution 3171 affirms the right of states to nationalise property, to determine compensation according to their own laws, and to...
The resolutions that you are mentioning are UN resolutions. What is the legal weight of those resolutions? You talk as if they were the international law. You said that.
Your Excellency...
Could you explain?
Certainly. According to Article 10 of the United Nations Charter, General Assembly resolutions are recommendatory in character only. However, this court in the Nicaragua decision recognised that General Assembly resolutions can evidence both state practice and opinio juris for the purposes of customary international law. It is submitted by Frontera that with respect to the Charter of Economic Rights and Duties, Resolution 3281, there has been sufficient reiteration of the principles found within it, that if we look to the drafting history, to the debates in the General Assembly over it, to the language the Charter uses, and to the voting patterns, that the Charter in fact represents customary international law.
But, Counsel, the mere reiteration of concepts or perhaps principles, does that evidence an emerging or rule of customary international law, or the crystallization of a rule of customary international law? As we know, with the Charter of Economic Rights and Duties of States, there were a number of states that voted against that resolution and a number that abstained. And they were the states most likely to be affected by the practice which is being proposed by that particular resolution. What do you have to say in answer to that?
Your Excellency, in the Nicaragua decision, they discussed the recitation of principles and that might contribute to state practice. It is submitted that there has been such reiteration in these resolutions, 3171, 3201 and 3281. With respect to the voting patterns, 104 states voted in favour of Article 22C of the Charter, which deals with nationalisation, an overwhelming majority of the international community. 6 states abstained and 16 voted against it. Of the abstentions, Frontera relies upon a remark made by the court in Nicaragua, which suggests that where states fail to exercise their right to vote no, they may be bound as having implicitly accepted the principles within these resolutions. Of the no votes, it may be that such states amount to persistent objectors alone under the Anglo-Norwegian fisheries case. They themselves will not be bound by principles of customary international law which emerge, but they cannot prevent the crystallisation of such principles. Your Excellency refers to states which are specially affected under the North Sea Continental Shelf case. They are required to acquiesce in the development of customary international principles. It is submitted that the states which are specially affected by rules of nationalisation are the host receiving states, the capital importing states, and their constant acquiescence in these principles and support for them aids in the development of these principles.
Counsel, you keep referring to nationalization, and your counterparts repeatedly refer to expropriation. Now, if nationalization is legitimate, could you tell us what kind of natural resources would pharmaceutical companies make, and what was the significance of whatever they were doing to the national economy of Frontera?
Beginning with Resolution 3171, Your Excellency, which was entitled Permanent Sovereignty over Natural Resources. These resolutions recognise that the principle of permanent sovereignty extends also to economic activities. Frontera concedes that there is not an issue of natural resources here, but that manufacturing industries fall squarely within the concept of economic activity. Your Excellency.
You said at the beginning of your intervention that was just a domestic affair, this expropriation or nationalization. However, the very international law that you are quoting, the Charter of Economic Rights, Article 2, when it refers to expropriation, it also mentions international law.
Your Excellency.
Then are you arguing that it's completely out of international law, this case, or not?
Your Excellency, Resolution 1803 of 1962 refers to international law being relevant. However, Article 22C of the Charter of Economic Rights and Duties refers to states being entitled to award compensation according to their own domestic laws and any principles that they consider pertinent. There is no reference to international law.
There is a reference. They said that the compensation should be appropriate. I think is the word that they use. But it's not absolutely free, the country. Even in that, if you read that article, it says, it doesn't say prompt, adequate, and effective, but it says appropriate.
Your Excellency.
Then it's an international criteria.
Some commentators have argued that even though Article 22C does not in fact mention or make specific reference to international law, that international law is nevertheless relevant. It is Frontera's primary submission and primary interpretation of Article 22C that notwithstanding the use of the word appropriate, this is a matter of domestic jurisdiction alone. The Charter of Economic Rights and Duties is supported in practice by the Latin American practice over the 19th and 20th centuries, by socialist practice in the 20th century, and by recent large-scale nationalizations in developing countries. I refer to Libya and Iran in particular, all of whom defended their nationalizations as being matters of domestic concern alone.
Have you consulted the new investment agreements between Latin American countries and the US? They use the phrase prompt, adequate, and effective. Then what you are saying, maybe it was, but now it's not.
Your Excellencies, Bastonia has also referred to the state practice on bilateral investment treaties, and it is certainly true that recent ones over the last 10 years have made provision in the most part for prompt, adequate and effective compensation. It is submitted by Frontera, however, that bilateral investment treaties do not contribute to the development of customary international law. First, because they are not norm-creating, as was required by the North Sea Continental Shelf case. But secondly, because they do not evidence the requisite opinio juris, that states enter into these bilateral investment treaties not out of a sense of legal obligation, but out of political and economic necessity. In the absence of opinio juris, Your Excellencies, customary international law cannot be formed. If Your Excellency...
Councillor, then, is it your opinion, as we look at these resolutions back in 1974, 1975, and try to apply them now in 1993, has there been no evolution? Do you think that the idea that appropriate compensation as opposed to and the emerging idea of adequate compensation is not a standard that we should be using?
Your Excellency, there certainly has been a development in practice with reference to nationalisation, and there have been a number of arbitral awards since those resolutions were passed in the early 70s. If Your Excellencies conclude, as did a majority of those tribunals, that in fact the Charter of Economic Rights and Duties is not customary international law, it will be submitted by Frontera that any relevant principles of international law have been complied with. In particular, I will move, if I may, to the issue of appropriate compensation. Bastonia has submitted also that there are requirements of a public purpose and non-discrimination. Frontera submits that it has complied with those, but due to the constraints of time, refers you to pages 17 to 19 of our memorials where we deal with those issues more specifically. Appropriate compensation requires an inquiry into all the circumstances relevant to the particular case, and I refer this court to the Ammon Oil Arbitral Award in which that was held. Furthermore, in the Liamco Arbitral Award, the court referred to equitable compensation, again suggesting a consideration of all the factors in a particular case. Here we have IPC, which has made excessive profits in Frontera. It recouped its initial investment over 100% in each year over the last 10 years. Moreover, it repatriated 60% of those profits while having only a 49% shareholding. The exclusive Bastonian management of Farmco suggests that IPC had little concern for the economic autonomy of the Fronteran people. And finally, Frontera relies upon its status as a post-colonial self-determining country undergoing economic self-determination, and particularly on its underdeveloped status. Relying on the arbitral decision of INA and on Lauterpact's work, it is submitted that its status as an underdeveloped country is particularly pertinent. Your Excellencies, my time is up. If I may briefly conclude this point. It is submitted that in the light of all these circumstances, that appropriate compensation will be nil. Thank you.
Madam President, members of the court. My co-agent has submitted that Frontera is not liable under customary international law to provide compensation for the nationalisation of IPC's investments within Frontera. Additionally, I will submit that Frontera is not liable under the bilateral investment treaty to pay compensation to IPC in Bastonia. First, I will deal with the formation of the newly independent state of Frontera, which was accomplished when the people of Frontera exercised their right to self-determination in the Revolution of 1990. The fact that a new state has been formed precludes the attribution of any liability to the present state of Frontera. Alternatively, if this court is to hold that Frontera is indeed bound by the bilateral investment treaty, then Frontera submits that it has not breached any of the treaty's provisions in relation to IPC's investments. Your Excellencies, turning to my first submission. Bastonia has submitted that Frontera is a continuing entity or a continuing state, and therefore it is bound by the treaty. However, the empowerment of the Revolutionary People's Government as the government of Frontera not only created a new government, but it also created a new state. Prior to 1990, Frontera did not fulfill all the requirements for statehood as stated in the Montevideo Convention, which expresses customary international law or reflects customary international law on this particular point. The four requirements as stated in the Montevideo Convention are population, territory, government, and the capacity to enter into foreign relations. In particular,
Excuse me, that 1933 Montevideo Convention Do you know how many countries vote in favor? The title of the convention is Rights and Duties of States. To what extent that represents international law?
Yes,
Or
Jackson.
if there is any other international instrument that refers to the elements of the state? These two questions.
Yes, Your Excellency. Firstly, as to the parties as the Montevideo Convention, there were in fact 15 Latin American states who were parties to the Montevideo Convention and also the United States. Frontera realises, of course, that neither parties in this dispute are in fact parties to this convention, but in fact relies on it as customary international law. These particular 4 requirements are referred to numerous times by commentators, in particular Crawford and Brownlee, as expressing the necessary customary international law. These 4 requirements are also used by particular governments when recognising new states in the international community, and therefore this is a consistent recitation of the principles which are expressed in this particular convention.
That is a regional convention. Is there any universal convention that refers to those criteria?
Your Excellency, there is no, in fact, universal convention which refers to these particular 4 criteria and sets them out in such explicit manner. However, the fact that governments have particularly referred to these 4 criteria on numerous occasions when referring to the recognition of new states expresses the necessary state practice in order to form the customary international law principles, or one of the elements of customary international law on this point. Your Excellencies, in particular, the 4th requirement, the capacity to enter into foreign relations, has been interpreted as meaning independence. I refer Your Excellencies in particular to the writings of Crawford and Brownlee on this point. Furthermore, even though it appears that prior to 1990, Frontera had the capacity to enter into treaties with other states and also the capacity to conduct its own foreign relations, in fact, it was the appointees of the Imperial Parliament which exercised this capacity. Bastonia has referred to 2 particular situations, that is, India and the British dominions of the Commonwealth. Frontera seeks to distinguish these 2 particular situations. Firstly, in relation to the dominions of the British Commonwealth, it was not only the Governor-General within Frontera who was appointed by the Imperial Parliament, but it was in fact also the colonial government, and I refer Your Excellencies to page 1 of the compromis on this point. Furthermore, within the dominions of the Commonwealth, they were in fact granted substantial independence and autonomy, a greater independence and autonomy than has been gauged within the compromis as regards Frontera. And I refer Your Excellencies in particular to the Balfour Conference of 1926, in which the dominions were expressly given a great deal of independence. There is no such expression in the part of the Imperial Parliament as far as we can gather within the compromis. Furthermore, referring to the case of India, Frontera seeks to distinguish India in these particular circumstances as it was a very unusual situation arising out of the division of the British India into firstly India and secondly Pakistan. It was seen at that time that it was expedient to allow India to take on the obligations of the former British India. However, Pakistan applied a clean slate rule. Therefore, in this situation, it is very different to the situation of Frontera, which is a colony emerging from its previous colonial status into an independent state. Your Excellencies, the criteria of independence has been stated by Judge Anzalotti in the Austro-German Customs Unions case as referring to an entity which is not subject to the authority of any other state. Where there is a relationship of a superior state and an inferior state, as is the case at present, as Impera is the superior state and the colony of Frontera is under the control of Impera, there necessarily can be no independence. Furthermore, Crawford has stated that the presumption is against independence where there is formal dependence. There is quite clearly upon this factual situation formal dependence upon the colony, upon the colonial power Impera, as indeed Frontera is a colony. Furthermore, Your Excellencies, the substantial autonomy granted to Frontera by the Imperial Parliament does not change its fundamental attributes as a colony. Bastonia has referred to United Nations membership as evidencing statehood in this case. However, despite the fact that Article 3 of the United Nations Charter refers to states becoming original members of the United Nations, in fact, it was recognised at the San Francisco conference that in fact there were numerous entities who became original members of the United Nations, despite the fact that they were not states. And I refer Your Excellencies to the examples of Belarusia, Ukraine, and the Philippines on this point, and also to the commentaries on the United Nations Charter by Keaton and Schwarzenberger, and Goodrich and Hambro.
Referred several times to your foreign minister's statements that the newly independent state would respect all the international obligations. How do you justify that?
Yes, Your Excellency. Frontera submits, in relation to its independence and its newly emerging statehood, that in fact a clean slate rule applies as to treaty succession. Frontera recognises also that it has been expressed that by its conduct a state can take on its treaty obligations. However, in relation to this particular situation which was mentioned by Bastonia, Frontera submits that in fact by its conduct it has not taken on the treaty obligations on this particular point.
But I don't believe that your minister referred to a conduct. According to your counterparts, an agent of the government of Frontera had addressed the world community by saying that we are respecting our obligations. How do you defend yourself in that?
Your Excellency, there are three particular situations which are referred to in the compromise, and if I may, I'll deal with each in turn in relation to this particular question. Firstly, there was a statement by the Fronteran ambassador to Bastonia, and it was a hope that the long-standing tradition of economic cooperation would continue. However, this particular statement does not fulfil the requirements for a unilateral declaration as expressed by this court in the nuclear test case and also by a chamber of this court in the Frontier case. The requirements for a unilateral declaration by a government official to be binding are firstly that there be a capacity to enter into such a unilateral declaration and to bind the state, and secondly, that there be an intention to create legally binding relations. In relation to particularly this second criteria, the hope expressed by the Fronteran ambassador when she presented her credentials to Bastonia do not fulfil this final requirement under the nuclear test case, and therefore is not binding upon the state of Frontera. Secondly, Bastonia has referred to the general law. The general law excludes treaties from its ambit. However, in relation to this particular law, it neither shows an intention that Frontera will be bound by its treaty obligations or that it will reject those obligations. It merely embodies the principle in Article 27 of the Vienna Convention on the Law of Treaties that states by their municipal law cannot act contrary to their international legal obligations, or in effect that municipal law will not take over international obligations in this effect. Finally, Your Excellencies, in relation to the statement by the Fronteran Foreign Minister in the United Nations, where it was specifically stated that they would repudiate all obligations which were inconsistent with the goals of the new government of Frontera, or the new state of Frontera, the Revolutionary People's Government.
I have two-part questions. Number one, in the treaty, did you have any reference to the applicable law if there was any dispute between the two countries? Did you have any clause which applicable law should be used in any dispute between the two countries?
Your Excellency, with regard to the treaty, a treaty necessarily between two states at international law, which is governed by the Vienna Convention, is of course governed by international law.
What about in your municipal law, after the revolution, in your general law, any general law, did you address any of the issues, dispute arising out of the claims related to the nationalization of the natural resources, etc.?
Your Excellency, as far as is evidence within the compromise, there is in fact no evidence as to what exactly the particular statements within the municipal law, or whether in fact it intended to be in particular relation to the bilateral investment treaty. In that respect, we could only speculate on the facts in regard to that matter.
Counsel, Am I correct that your country enacted a law which vitiated the laws with which they did not agree, but accepted international agreements from that? Is that true? And if so, what impact does that have on what you're saying?
Your Excellency, as far as we can tell within the particular general law, it would seem that Frontera has repudiated particular laws of the former colonial government, which were inconsistent with the aims of the revolutionary people's government. However, it is unclear upon the general law whether international obligations are in fact evidenced or are dealt with in this particular law.
Is it your understanding that the new government was a proper action to be able to pick and choose amongst the laws that they decided to keep and those that they decided not to any longer adhere to?
Your Excellency, within a municipal law of a state, it may of course choose, a particular government may of course choose which laws it will take on and which laws it will not, and which laws it will enact and which laws it will decide to repeal.
I understand that, but my point then, the next question is, can they do that as well with the international treaties? Can they decide, I like this one and I don't like that one?
Of course, Your Excellency. Referring particularly to international treaties, Frontera submits that as it was indeed a new state, that a clean slate rule applies to treaties in this relation. The clean slate rule embodies the notions that a state starts life with a clean slate in the respect that it has no treaty obligations in respect of its predecessor government, although it may of course take on such things, and although things such as dispositive treaties which affect land may in fact be inherited. In fact, in relation to a bilateral investment treaty, it is submitted by Frontera that the clean slate rule applies. The clean slate rule is customary international law on this particular point, and it is evidenced by state practice.
You mentioned the case of Israel. You see, there is what is common between your case and Israel.
Your Excellency,
applying that theory.
in relation to the particular example of Israel, Frontera merely uses it as an example as showing that where there is a new state, there is no continuance with treaty obligations of the former entity which was upon that particular territory. In fact, the situation may be dissimilar in a number of aspects, but however, it is an example of an entity which applied a clean slate rule. If Your Excellencies prefer, there may be a more similarity between the examples of Uganda, Kenya, Malawi, Botswana and Burundi, which were in fact newly independent states and which, according to the Nyeri Doctrine, did not have to take on the obligations of their predecessor governments. Bastonia, in its memorial, has referred to a number of states which have signed devolution agreements. Frontera submits in relation to these agreements that firstly, they are not binding as far as third parties are concerned, and in fact, many states decided not to act in accordance with their devolution agreements signed with their former imperial powers. And I refer Your Excellencies to the example of Nigeria, which in fact took on only 7 of the 222 bilateral treaties which were in existence upon the previous colonial entity of Nigeria. Frontera also recognises that the Vienna Convention on the Succession of States in respect of treaties is not signed by either parties in this case, and of course is not in force, as the necessary ratifications have not been received. However, the International Law Commission, when outlining this particular article, examined the necessary state practice and also the state practice that I've referred to, and recognised that it was embodying the principle of customary international law on this point, and therefore it is submitted by Frontera that in accordance with these principles, it is the applicable law to apply in this dispute.
Just very recent, the practice of the Balkanization of the Soviet Union with all those new states. You don't find it, don't you think that that could be representing the new international law on the subject?
Yes,
you have not mentioned that are very close to us.
Yes, Your Excellency, that is true.
That?
Sorry. Frontera recognises that there may be a concern among this court, particularly with the recent events in the former Soviet Union and also in Yugoslavia, that indeed there may be a concern among this court that it could create chaos in international relations in regard to this particular point of the clean slate rule. However, Frontera seeks to distinguish these particular examples of secession as distinct from the example of decolonisation. I refer Your Excellencies also to the discussion by Henkin and Crawford in the Society of the American Proceedings on International Law, where this particular issue was discussed. And it was recognised that in the case of secession, there may be an obligation to take on existing treaty commitments in relation to some treaties. However, it was explicitly recognised that decolonisation, which is the situation we have at present, is a very particular circumstance and that a clean slate rule would apply. Your Excellencies, turning to the breaches of the treaty, Bastonia has failed to show that indeed Frontera has breached the bilateral investment treaty. If this court, and this is an alternative, was to hold Frontera bound by the treaty, then Bastonia must show that it has breached the treaty before compensation would be required to be paid by Frontera. However, Frontera submits that it has not breached the bilateral investment treaty. A chamber of this court, in the electronic Sicular case, has held that reference to constant protection and security, which is the phrase used in Article 10, can never be construed as a warranty. The property will never be damaged, or indeed will never be disturbed. Furthermore, in the AAPL case decided in the International Centre for the Settlement of Investment Disputes, it was again stated that an article such as Article 10 could not be construed as an absolute obligation in the sense that there would be a guarantee that no damage would be suffered, and also in the sense that there would be strict liability upon the host state. It may be that Article 10 does prevent damage by a third party in relation to investments within a territory. However, it is submitted by Frontera that it does not include the nationalisation in this case of IPC's investments. In particular, Your Excellencies, those states which have signed numerous bilateral investment treaties have included anti-expropriation clauses. And if Bastonia and Frontera had envisaged this situation arising, then it would have put such a clause in as well. It's submitted by Frontera.
Counsellor, if such a clause had been in the 1980 treaty and an investment state was relying upon that, by your rules of succession, you'd say that they couldn't rely upon that, even detrimentally, and be protected under international law. Is that truly your position? I think that's what bothers me, is the idea that in succession, in a developing, politically fragile environment, which is desperately in need of investor state capital, can the investor state and its investing citizens rely upon some framework, or is it subject to a clean slate rule?
Your Excellency, firstly in relation to this particular treaty, Frontera submits that indeed it is not bound by the treaty in relation to the customary international law of the clean slate. Secondly, in relation to the provision as to constant protection and security, submitted by Frontera that it does not in fact include expropriation. There is no evidence upon the facts in the compromise that IPC relied upon the treaty when it placed its investments within Frontera. Firstly, because IPC indeed placed its investments within Frontera prior to the treaty entering into force. Therefore, within the particular principles of estoppel, which Your Excellency has referred to the concept of reliance, in the North Sea Continental Shelf case and also the Temple of Puervia case, both decided by this court, it would seem that there would need to be detrimental reliance. In this respect, IPC cannot rely on such a principle in order to, as there is no detrimental reliance upon the facts, and therefore it does not cover IPC's investments. Your Excellencies, finally, it is submitted by Frontera that Article 12 and Article 13 limit Article 10 by stating that if there has been a breach of the treaty, compensation is only payable and is required if it is given to all states in the same position. Submitted by Frontera that as compensation was not given to all states in the same position, I refer Your Excellencies to paragraph 3 of page 3 of the compromise. Therefore, this article has not been breached. Finally, Your Excellencies, any obligations under the bilateral investment treaty have been expunged by the application of Article 14. If there was a breach of the treaty, Your Excellencies, I see my time is up. May I briefly conclude this point on Article 14 and then conclude, or would you prefer I concluded.
Straight to your conclusion.
Yes, Your Excellency. I would refer Your Excellencies to page 16 of our memorial for a discussion of Article 14. In conclusion, Your Excellencies, Frontera asks the court to declare that first, it has acted in accordance with its right, established a customary international law to nationalise IPC's investments. Secondly, Frontera is not responsible for any liability under the bilateral investment treaty, which was entered into prior to the Fronteran people exercising their right to economic and political self-determination. Thank you, Your Excellencies.
Your Excellencies, my friends from Frontera have acknowledged that a nation may not be bound if it does not have the opinio juris, does not feel bound to an asserted principle of customary international law, then that principle cannot be applied against it. Although the compromis is silent with respect to whether Bastonia is among those nations which have objected to Article 2.2c of CERDS, the controversial provision of the Charter of Economic Rights and Duties of States, it is reasonable to infer, based on its highly developed and highly industrial status, that it was among those nations. And therefore, Frontera can derive no comfort from the purported lack of a requirement for acting in accordance with international law. I would note also to the court a statement made by Secretary General of the UN, Boutros Boutros-Ghali, in January of 1991, wherein he stated that the micronationalism that resists healthy political and economic integration can destroy a peaceful global existence. Yes, Your Excellency.
What is the legal value of that statement?
Your Excellency, I merely point to this in reference to submissions of Frontera with respect to deciding this case on policy objectives, and that Secretary General of the United Nations spoke to this precise issue.
You are opposing all the same that you are criticizing policy statements.
No, Your Excellency. I am not asserting that this is a legal principle which is binding upon the court. It is merely reflective of the international community's interests in these matters. I would also turn to the assertion by Frontera that appropriate compensation in this case is zero. I would note to the court again that the negotiating stance which Frontera took with Bastonia was that it always had a right to nationalize without any compensation. The appropriate compensation as zero is a change in this position, and had they asserted that there was a requirement, had they recognized the requirement for appropriate compensation, then Bastonia would not have had to come to this court to obtain relief. I note that this court need not decide or quantify the amount of compensation that is due. Bastonia merely requests that you identify that there is an international obligation to provide compensation, an obligation that Frontera refuses to admit. With respect to the independence of Frontera, I note the third sentence of the compromis, which states that Frontera had substantial autonomy. We also inferred substantial autonomy from the original membership in the United Nations. And paragraph 2, clarification number 1, suggests that Frontera's colonial status was merely a formality. In that sense, Frontera must be considered to be bound by its prior obligations. The application of the clean slate doctrine is inapplicable in this case. I would note that the examples that Frontera...
Before you move to that subject, are you trying to tell this court that this is unjust enrichment, taking of property? Is that your doctrine you're referring to when it comes to compensation?
In effect, yes.
Are you asking us that this is unjust enrichment and you're asking for some quantum merit?
Yes, Your Excellency, this is in fact unjust enrichment. As Agents for Frontera have recognized, this is not an issue of natural resources. In reality, it is a transfer of technology. Bastonia has brought this transfer of technology into Frontera, it is reasonable to infer from the from the process involved here, a pharmaceutical company, which is a highly technological process, and that based on this factor, on the taxes that Bastonia pays to Frontera, the lease rents that are reasonable to infer Bastonia pays, the provision of a working environment for Fronterans, that Bastonia has merely been compensated for its investments, and that if Frontera wishes to deny, if Frontera wishes to suggest that there is unjust enrichment on Bastonia's case, its remedy is not to unilaterally act in expropriating Farmco, but to renegotiate the terms therein, to reach favorable terms for Frontera rather than completely taking away IPC's interests in that company. As I see my time is short, unless the court has any questions with respect to the clean slate doctrine, I will yield, I will rest Bastonia's case. Thank you.
Your Excellencies, in Sarabuttal, Frontera makes 2 points. Bastonia referred to the developed states which had voted against or abstained from the Charter of Economic Rights and Duties. Certainly, some industrialised states voted against it. Many, however, abstained. Some, in fact, voted in favour of the Charter, and I refer in particular to Australia. Your Excellencies, I remind you that Resolution 1803 is said to reflect customary international law, even though the entire Soviet bloc abstained from that particular resolution. If we are to look to policy considerations, as Bastonia has suggested, it is submitted by Frontera that the principles of the new international economic order, which was adopted by consensus by the General Assembly, more appropriately reflects the collective will of the international community. And the principles within that particular resolution are those of sovereign equality in the economic sphere, of the sovereign right to economic self-determination, and fair and just distribution of wealth amongst the community of nations.
That the charter was adopted in '74, and now we are in '93. And that is what is valid?
Your Excellency, is submitted by Frontera that the Charter has been relied upon by various states since '74, that Iran and Libya, in their nationalisations, both relied upon the Charter to establish their nationalisations as a matter of domestic jurisdiction, and that there has been state practice since then which suggests that the Charter...
No one questions that that is domestic jurisdiction. The problem is the criteria to measure what can be done and what is against international law. But no one questions.
Your Excellency, on the issue of appropriate compensation, it is submitted that this is the standard at customary international law, if customary international law is held to apply. And I refer Your Excellencies to the Texaco and Amanoil arbitral awards, in which the standard was held to be appropriate compensation. Such appropriate compensation requires a consideration of all the circumstances in this case, and I refer to Amanoil and to Liamco on this point. Also, if there is an issue of unjust enrichment, according to the Sealand case of the Iran-US Claims Tribunal, there will be, by necessity, a consideration of all the factors, as this is an equitable doctrine. In the light of all the circumstances of this case, to which I earlier referred, in particular to IPC's excessive profits and to Frontera's status as a developing country, it is submitted that appropriate compensation is nil. Thank you.
I understand that we will now adjourn and deliberate, and we will be back as soon as we have reached some type of decision. So if you will bear with us. Thank you. Please be seated. May I say, first of all, that we have come to a unanimous decision, and first of all, that is to give you our comments before we give you the results. I would like to begin by saying how very much we have, all of us here on the bench, have enjoyed actually judging today. There's been some tremendous participation. I know that at this stage of the competition, the two opposing teams reflect the highest standard of advocacy. We have seen much of that demonstrated in the court this morning. Your presentations were excellent on both sides. Great clarity of presentation, very clear, very to the point, very crisp. Good, well-balanced arguments. You've demonstrated, both of you, a very good knowledge and use of the law in your oral presentations. You placed great reliance upon authorities. And I noted in particular that you were both sides were able to argue very effectively by analogy. You produced some very ingenious and often very persuasive arguments. And I'd like to congratulate both of you on doing a very, very fine job. I would hate that you just go away with my comments. There are a few additional comments from some of my co-judges here on the bench. I'd like to go first of all to Farin.
Thank you very much. I thought both teams were excellent, as our Madam President expressed beautifully. This has been a wonderful experience for me to sit here and listen to you. You had done your homework beyond my level of expectation. You were just wonderful. However, I would like to make some comments, and I'm sure that later on you will find it useful. So please do not feel that this is anything personal, but on the Bastonia team, I think David had a very difficult task because he was the first one to stand up and talk. So probably he was a little anxious at the beginning, but then he started, getting things organized. On the other hand, the second team was probably a little more prepared because they had listened and they were in this defensive position. But I thought Frontera was more organized as far as the issues they were going to talk. Both speakers, when they came, Susan and Allison, they were both prepared to say, this is what I'm going to say. 1, 2, 3. This is wonderful. In every court appearance you have, whether it's in your own jurisdiction or before an international court of justice or any international court, it's wonderful if you tell the panel of the judges what you are going to say rather than to stand there and then decide, based upon how things are coming to your head. So it's very good to be organized. Both parties were organized beautifully, but I think Frontera was a little more organized in being specific, going to the specific issues. And I also thought that both Allison and Susan had fantastic oral argument, and they represented their case beautifully. They were prepared with the sources of international law. Susan, you were just wonderful in giving the sources. You knew more than I expected. However, in two cases, the Setco and the Sealand case, I think it's not your problem because these cases have not been dealt with so much. I represented a party in Sealand, and we won the case. So the problem was that I think you had not had enough time to deal with these two cases. There were just a little bit difference of, how the factual pattern were, and they were not completely the same factual pattern. But I congratulate both parties as far as knowing the sources of international law. You were great, both parties. Thank you.
I'd like to reiterate the comments that have been made. I think it's particularly interesting the speed of this round would indicate that there really was no hesitation on questions. You gave the answers, whether it was using ingenuity or reference sources. I must say I did not expect the argument of equity to come up on behalf of Frontera, and it was used very persuasively. Congratulations to both of you.
I would just like to also say that I thought both sides did an amazing job. I would I was also astounded by the equity arguments on the side of Frontera. I had read the papers, and I thought, in a strange way, I thought both you two gentlemen had a more difficult task because I believed in what your papers said, and I thought it was hard for you to kind of come forward and make it even more interesting for us, but I think you did a very good job. I would hope that some of the people who appear before my commission would be as good as both sides.
Well, I join my colleagues in praising you, and I just would like to comment in relation to the memorials, not to what we saw here, that I think they were good but not excellent, because they were basically a list of arguments to support one view instead of putting together opposite arguments in both memorials. But that in the oral phase, that was overcome. Just to mention that. Thank you very much.
Thank you. That leaves me with just one task, as you all realize, and that is to announce this year's winner of the Jessup Cup and the Jessup Award. I understand that first I will give the results, and then the presentations will follow after. By unanimous decision of 5 votes to 0, this bench has decided that Susan Brennan and Alison Duxbury are this year's winners. Congratulations. I'm sure that all my colleagues here on the bench would like to extend their warmest congratulations to all of the team. I know that Susan and Alison pleaded, but there were more of you involved. And also our congratulations to the runners-up, University of Hawaii, represented very admirably. Represented very admirably by David Foreman and Andrew Bunn this morning. And then we would also like to announce the best oralist in the final round of this competition. This was a very close call indeed. It was hair-splittingly close, in fact. But once again, it is a unanimous decision, and the best oralist is Susan Brown. That concludes this round, and thank you all very much for participating. We have enjoyed ourselves, as I'm sure you have too.
I'd just like to say for all the other teams that have been going on, and some of you are in this room, I think it's just an exciting, great experience for all of you, and I hope you had as much fun as we and all the other judges who have participated in this program throughout the months that it's gone on.
Pleased to give you the winning team of the 1993 Philip C. Jessup International Alumni Competition. And not to be slighted, Hawaii also has 2 awards up here on the table. The first, of course, is the fact that the University of Hawaii, prior to coming into this competition, was named the United States National Champion in the competition, and we have elected to hold that award and present that to them here as well. So we will do both at the same time. We'd like to present the team from Hawaii, University of Hawaii, both the U.S. National Champion and the runner-up in this year's competition.
Thank you. Although it would have been very nice to win, we were very pleased to represent the University of Hawaii's William S. Richardson School of Law, especially given the subject matter and the spirit of the Jessup competition. I'm not sure if everybody here is aware, but this is the 100th anniversary of the illegal overthrow of the Hawaiian Kingdom. There is a sovereignty movement in Hawaii, and however you feel about this issue, I encourage people to educate themselves about it. Until we meet again.
Brett said we could also take a moment to give some thanks to people in the hopes that in the future it might encourage them to contribute more in our fundraising activities for this event. We would like to thank someone whom I think a number of the participants here are familiar with. It's our professor, our international law professor and coach, John Van Dyke, who was unable to be with us. And we would also like to thank our Dean, Jeremy Harrison, at the William S. Richardson School of Law at the University of Hawaii for his support, as well as the support of his staff, the faculty, the student body. Furthermore, the Hawaii State Bar Association and the judiciary at both the state and the federal level. And I'd like to encourage everybody here, and if this is on video, anyone who should see that, to give your support to the Jessup competition, because this is the greatest moot court competition in the world.
On behalf of the Melbourne University Jessup team, I would like to thank the judges and administrators of the competition. The best part was interacting and with all the participants from the other teams, and we thank all the other teams for this unique and exciting international experience which we've had.
I'd like to now present the award for the best oralist in the final round of the competition. Again, I would like to remind you that in the preliminary rounds, we have best oralist has been elected for the rounds that got them to this point, and we should probably recognize that person now as Mr. David McCauley from the University of Hawaii. And as the judges noted, in this final round of the competition, they have determined that the best oralist is Ms. Susan Brennan from the University of Melbourne.
I'd just like to reiterate what Tony said and thank also Wayne and Ian and Hilary and Penny, who were my role models as an international lawyer, and also the Department of Foreign Affairs, because they did get us here financially. I think the interesting thing about winning an award like this is that it was Byron who told me about expropriation, Alison that told me about standing, Boots that told me about the treaty, and Tony that told me about state succession. And each morning they'd run in and say, you've got to say this, 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 and this case, and that happened then. And without their knowledge, I really wouldn't have had anything to say. So thank you.